Welcome to today's Brexit seminar. What we're looking at today is focused on the plumbing and heating industry, and in particular, minimising risk for your company and maximising opportunities. It's going to be relevant to sole traders, to a FTSE 250 listed company. We're going to look at two scenarios today. One is a no-deal hard Brexit. Alternatively, we're going to look at the deal. And I do appreciate that the extension now has been agreed to the end of January of next year. The information provided today is from an English and Welsh legal perspective only. If you need legal advice, please get specialist independent legal advice on each issue. First issue, regulatory changes. Firstly, as you may have read, we're going to have the doctrine of what's called equivalence. We're going to follow the EU for the short term as much as possible. There might be some minor changes. So for example, the CE mark will change to a UK CA safety mark. There will be a transitional period post-exit for up to 18 months for changes to take place in the UK, but actually changes must be immediately in effect for EU changes. You're going to see new labelling and compliance coming through. You'll change from being a distributor to an importer, and that will change the legal issues that you have and challenges that you face going forward. In summary, regularly check the government's website, which will appear on the screen now. Now let's move on to your commercial contracts. Some top tips. Have a look at your existing contracts. What happens where there's a material adverse change? What's the contractual impact on your business? If it's unclear, get it changed now. You can seek to vary or enter into a new contract as soon as possible. Do you have a force majeure or what's called an act of God clause? Now, Brexit may be fundamental, but I don't think you can adequately describe it as an act of God. So I think contractual relationships will change, but they won't be so fundamental that you can walk away from your contractual obligations as a result of Brexit. Going forward, have a look at your new contracts now. Think about what a Brexit clause might look like. You're going to see changes in pricing, in tariffs, in the cost for labour, in purchasing hardware, the regulatory environment. Who shoulders that burden? Is it you? Is it your supplier? Or is it the ultimate customer? Set it out clearly in your contract so everyone understands, and it minimises the risk of dispute and maximises the recovery of profit out of any commercial deal. Do keep an eye on consumer protection laws. At the moment, as I said earlier, on the regulatory side, there's no immediate effect likely. We are focused much more on equivalence. But going forward, with the mid to long term, there will be changes. So keep an eye out for those. In particular, look at where it's only EU regulations enforced as opposed to English law. In that case, it's quite likely that the EU regulations will fall away. Principles such as good faith in contracts, that's likely to fall away as well post-Brexit. And then finally, when you're in a dispute which you simply cannot avoid, what do you do next? Now, I'm only talking about disputes where there's a cross-border element. In other words, a dispute which is outside of the UK and one that relates to the EU. If you have a dispute where, for example, your customer is located outside of the UK, or its assets are outside the UK, then have a think about what you want to do next. Pre-Brexit, you may wish to issue proceedings without further ado. The reason being is that once the English courts have claimed this action, then they can generally deal with it going forwards. If you have a UK judgment and you need to have it enforced in either the EU, Norway, Iceland or Switzerland, consider taking enforcement action now. If you do not, it might be too late, because post-Brexit, the EU may not respect an English judgment in quite the same way. The purpose of enforcing now and moving quickly is to save costs and give you certainty. And finally, how can you avoid all these risks and costs in commercial contracts where you have a party which is outside of the UK? Well, one suggestion is to have a very clear clause which states that English and Welsh law has exclusive jurisdiction and of choice of law for your contracts. Secondly, have a think about an arbitration clause, because arbitration clause, so long as they are enforceable, will not change, and any award given by an arbitrator will be enforceable throughout the EU in the usual way. In summary, by way of a recap, In the short term, regulatory equivalence is likely. Secondly, Brexit-proof your commercial contracts, but well before the end of January 2020 deadline. And finally, consider now putting in new clauses in your contract, say either an arbitration clause or an exclusive English and Welsh choice of law and jurisdiction clause, so that you've got commercial certainty going forward. Thank you for your time.